Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Sydney Osmar.
And I'm Sumit Malhotra.
Welcome to Hull on Estates, and you are listening to episode number 707. How are you doing today, Sumit?
I'm doing good, Sydney. How are you?
I'm good. I'm glad it's a Friday.
Absolutely. Lovely weather. And then first snow for Toronto as well. So really happy as well.
Oh, that's great. Well, so today for our listeners, we thought we would talk about something that's important for all lawyers, regardless what area you practice in, and that is capacity, specifically as it pertains to your client. And what got us thinking about this topic is the Law Society of Ontario actually recently released a new guide on navigating client capacity concerns. And our partner, David Smith, actually, he recently blogged on this. So the link can be found on our website, but of course, you can also just access it through the LSO website as well. And so with capacity, it's interesting. And as a lot of our viewers and listeners may know, there's no single definition for capacity. And for that reason, there's also no one test for capacity. And test is probably not really even the right word for it because it really is more of an assessment of different factors depending on what's going on. And as we know, capacity is it's time, situation, and decision specific. So it can mean different things depending on what's happening. So, for example, with time, it fluctuates over time, capacity can. And sometimes we could have an elderly client who they may do better in the morning than at night. Situation specific, if someone's going through a great amount of stress in their life, this could impact their capacity, decisional capacity. And decision specific, depending on what it is the person wants to do, there are varying levels and factors that need to be considered. So you can be capable of doing one thing and potentially not another. For example, it's not uncommon that we could have a client be capable of granting or revoking a continuing power of attorney for property, but not actually have the capacity to manage their property themselves. So that was sort of just a little intro into capacity and why it's interesting and linking into the fact that there are different levels for what it is that you do or do not the person seeking to do in the context with clients. Sumit, could you tell us what the factors are to be considered for the capacity to instruct counsel?
For sure. Thanks, Sydney. When it comes to capacity, I agree with you. There's not a fixed concept. And then always there's a rebuttable presumption that an adult client is capable of instructing the counsel. Now, in order to understand the capacity, I would say the client must have ability to understand the financial and legal issues at hand. And this was also discussed in Evans versus Evans, that is 2017 Ontario Superior Court decision. In that, court found that evidence indicating an individual's current mental status, which prevents one from dealing with the process, is not sufficient to prove incapacity to instruct counsel. It must specifically address the issues of whether one can make decisions regarding the process. Now, I would also like to shed some light on another decision, that is Constantino versus Constantino. That was 2016 Superior Court decision, where the court says that the client must be able to understand the context of the decision, what one has asked the lawyers to do and why. There should be, one should know one's own specific choices, be able to understand and process the information, as well as advise and provide options that the lawyer presents to them. They should be able to appreciate and the consequences of one's choices. That is, appreciating the pros and cons and potential results of various options. So, in overall, those are the things which the counsel should address while seeing the capacity.
Thank you, Summit. And so those are some of the tests. Again, I'll use that for lack of a better word that's come out of some of the jurisprudence. And the LSO guide it's very helpful because it's kind of taken those tests and put together a resource for lawyers to refer to that sets out a series of red flags of what to look for, some tips on what to do if certain situations arise during your retainer with the client. So it takes the law and kind of gives you a practical what to do in real life situations guide. And so the guide actually starts out setting out what some of the requirements, the professional obligations we have as lawyers are. And so the LSO's requirement is that a lawyer must maintain as reasonably as possible a normal professional relationship with clients whose decision-making capacity may be impaired. And if a client lacks the capacity to manage their legal affairs, licensees, so both lawyers and paralegals, must safeguard the client's interests. And that might be having to eventually appoint a lawfully authorized representative or a substitute decision maker if the person hasn't already made arrangements and have a person in place to be their substitute decision maker. And so in the guide, the LSO has actually provided some tips and ways that accommodations lawyers can implement to maintain as normal of a relationship as possible. And what were some of those tips for accommodations?
Yeah, so thanks, Sydney. In order to go forward with normal professional relationships with the clients whose decision-making capacity is impaired, what lawyers should do is basically to reduce this is they should conduct meetings, obtain instructions with clients' preferred communications medium. If the person is good with in-person meetings or in writing or virtually, the client should, like lawyers should give more importance on what the preferred choice is. Reducing all legal advice as well as clients' instructions to writing, because in writing it's more of protecting lawyers as well. If you have everything in writing, and then we feel client would be able to understand much better in a way. Sometimes if it's written, they can revisit the documents again and again. Next would be encouraging the clients to ask more questions. This is important because they should, like lawyers should make sure that clients are understanding, and then with questions, it gives more clarity on perspectives of what needs to be done. Providing additional time for clients' instructions. Sometimes some clients might take more time to understand what's going on and to study and then to give you feedback on it. So the lawyers should give more time to clients. And then next would be offering regular breaks. Sometimes breaks in a sense in the client meetings, I would say. So sometimes the meetings are very long, and then clients, they need to relax and recalibrate everything in order to move forward with the file. So lawyers should work on getting a more regular breaks during the meetings. Next, under the LSO's guideline is meeting with the clients in the different times of the day. As you said, Sydney, initially, sometimes clients might be more active in the morning, might not be able to give you more prompt responses during the night. So it should be lawyers' responsibility to accommodate the clients based on their perspective, when they would like to meet, at what time they prefer. And then next is using an interpreter. So sometimes we deal with clients. Canada is a multicultural. We deal with various types of multicultural people where everybody has their own language. So it is important to have an interpreter, sometimes a translator, to assist them, to guide them with the process. Next, I would say, is using very simplified and clear language, not even in communication, and also with the affidavits or any court documents, so the clients know what is exactly going on, what the purpose of the document is. And the last one, it says here that allowing the client to bring a support person, and that is important. Sometimes there are elderly clients, especially in our field, where we deal with a lot of elderly clients, and then we deal with wills. And so make sure that there's a support person who's assisting them, taking care of all the things, making notes for them. So those are the perspectives that we should consider while accommodating the clients to have a normal client relationship, like normal professional relationship.
Thanks, Summit. And so, like with capacity, knowing that it's so contextual and specific to each person, each situation, each decision. These are just, they're tips and examples that the LSO has put together, and it's going to be different for every client. You'll have to. It's really for the lawyer to get to know the person and figure out what their needs are and how best you can accommodate them. And now so a support person it's a really interesting topic because many clients have them and need them. I mean, we all do. We all in our own personal lives have support people that we soundboard ideas off of and get their opinions from. But for lawyers, we do also have to be very careful with support people because sometimes they can, whether they even mean it to or not, they can go too far across the line of influence, and it could become undue. I know, as like working in wills and estates, if you're a solicitor, a drafter, you have to be very aware of this and making sure that your instructions for the will are coming from your client. Lawyers generally, you have to make sure that at the end of the day, your instructions are coming from the client. So, for example, if you have an elderly client who isn't very tech savvy, and so they have a adult child or a friend that's helping them with email correspondence and setting up meetings, it's best practice to still, like if the email's coming from the child, make sure you give the client a call, you send them a letter, you're getting the instructions from them and not from the support person. And the LSO guide has actually, they're obviously been aware of that risk. And so they've put together more information on and tips and things to look out for. They've identified as red flags, and specifically in the context of undue influence or duress. And so, if something like that has come up, where a lawyer is sort of thinking, there might be more going on here, the Law Society put together a list of self-reflective questions that lawyers can ask themselves. And so, if this has happened, some of those questions are, what are the facts or circumstances that have led you to believe the client might be lacking capacity or might be being subjected to undue influence? And has the client exhibited that behavior before? Was the behavior in response to a recent stressful or negative experience? What decisions actually need to be made? And when does the decision need to be made by? And can accommodations help to provide the instructions? And can steps be taken to remove the influence of the third party? Because sometimes, you have a client who's come in with a support person, you ask that person to leave, and then you sit down with the client and you can get those instructions one-on-one with them. But then they go home with that person, and then they continue to have that influence, and they may call back and change their mind. And so it can be a very tricky and difficult situation to navigate. So those were some self-reflective questions that the guide has provided to lawyers, but they have also provided some examples of what to do if certain situations arise. So, Sumit, do you want to go through what some of those examples were? I think the first one talks about if your client had recently had a head injury.
That's right. Thanks, Sydney. Yeah. So addressing the red flags, it's important to see, as you said, and to ask follow-up questions whenever you see any such kind of red flags. So with the first one says client has a recent head injury. So you can potentially ask follow-up questions, and then regarding the injury, regarding you can obtain medical records, or a letter from a doctor to understand what's the gravity of the injury is, if it's going to impact anything. You can always do your due diligence on that. Second one is if the client has emotional outbursts that are not consistent with legal situations. You can judge that with the way of how things were being handled in the file, and then you can ask questions on about the client's life, if anything is bothering them, if anything is going on behind the scenes we might not know with our normal client, and solicitor relationship. So those are the follow-up questions you can ask. The next one is the third party is overly involved in the professional relationship. So we often see where clients come with their kids, with their parents sometimes, and then we see some of them are mostly more involved in the situation. So we can ask like open-ended questions about how did the decision was reached. Like was this your own decision? Did you meet with your family? Did you decide together? What was the reasoning? How they came to this conclusion? And then we can also stress on the nature of relationship with the third parties. Like as you said, we can sit with the client alone and then discuss, and then you can try to go deeper into that conversation. So that's helpful. The next is if client expresses inability to make decisions for themselves or fear for third party. Sometimes it happens like client comes to make a will, and then, as you said, they are under influence from their kids, maybe from the spouse. They want to do something different. So it's always good to have uh, the conversation with the client alone. It's important that you take the third party off the table and then sit with the client, ask the client direct and specific questions to determine if they are dependent on any third party or subject to any threats or any form of coercion. So those are the things we should address. There are different ways, different things can come up. Obviously, it's all about improvising and safeguarding your client. That's the main thing which we need to protect. So.
Thanks, Sumit. So after having that discussion, the LSO guide then goes on to give some examples of what lawyers should do or consider if it becomes clear that the client does likely lack capacity. And that is firstly to determine if there already is a substitute decision maker in place. People may have already had that capacity planning taken care of. And if they haven't, considering, and I mean, even if they have, considering whether a capacity assessment is required, just to have that comfort and so you can assure yourself of their capacity. There's also considering bringing a motion in court or before a tribunal for a determination of capacity or getting direction from the court, taking steps to have a substitute decision maker appointed if there isn't one in place. And then, of course, the final and sort of last substitute decision maker of last resort is the public guardian and trustee, in considering whether their involvement is needed. The guide, so it's very helpful, and it in addition to having just those, tips and things to look out for and red flags, they also link a bunch of resources throughout the guide. Like, for example, there's a worksheet on undue influence, and many of the resources are from third parties, the Law Commission of Ontario, the Public Guardian and Trustee, Well Partners, Elder Abuse Ontario. So it's really great. We'd encourage everybody to check it out. And the guide actually concludes with practice area guidance specific to what you may practice. So, if you're a wills and estates lawyer, they've got a section for you. If you're a real estate lawyer, a family lawyer, it's all broken down by practice area. So it's a great resource. We definitely recommend everybody to check it out, even just to have a refresher. We all deal with clients, obviously, every day, regardless what you practice. So it's helpful to have that in your toolkit. And I think that will bring us to our end of our podcast today. Thank you very much, everybody, for listening. And thanks for your time today, Sumit. I hope you have a great weekend.
You too, Sydney. Thank you. Bye.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.